Second part of the reading commentary. Original will should have to be filed with probate /LA petition. If original will has not been filed with probate /LA petition, then it is necessary to give direction to the petitioner to file original will, and probate /LA petition will be admitted only after the receipt of original will. All original documents will be directed to be kept in the safe custody of the court. Any person who wants to oppose probate or LA proceeding after general or special citation has no right to file objection, petition, written statement like civil suit. He has to file a caveat under section 284. The form of caveat is given in the schedule. Caveat should be either in the form of an affidavit or an affidavit will be attached with it. When the caveat will be accepted by the court, then the court can order to file written statement of the objection petition. The next question is, when caveat is to be allowed? If there is a caveatable interest, then only caveat can be allowed, otherwise not. Caveatable interest means the person filing the caveat must show prima facie that she either under the will or otherwise has got interest, even if it is slightest or remotest, in the property covered by the will, or he may derive some interest from the testator if there would not have been any will in existence. To be more clear, if a person can institute and maintain a suit on his own title and interest, then in respect of such property which is subject matter of probate shall be presumed to have caveatable interest in such proceeding. The next question which arises is whether the provision of Order 22 CPC regarding substitution and abatement is applicable to probate or LA proceeding. The answer is, if there is a named executor in the will and probate petition has been filed by such executor who dies during the pendency of proceeding, then there shall be no substitution. Such proceeding will die its natural death. There is no provision in the Act for substitution of objector who dies during the pendency of the proceeding. His or her heir or heirs, if have some caveatable interest, then he or she shall be at liberty to lodge caveat afresh. Provisions of Order 22 CPC are not applicable, hence no question of abatement arises. If petitioner in a proceeding for letters of administration dies during the pendency of such proceeding, then his or her legal heirs can be substituted. In order to meet the ends of justice, in one case, the Honorable Supreme Court, in its appellate jurisdiction, permitted substitution of probate petitioner who was not an executor and wrongly filed petition under section 276 of the Act with a prayer to grant probate, holding and treating such petition as a petition for letters of administration. This is the only judgment in which the Supreme Court permitted on account of long pendency of the matter before the Bombay High Court, and the Bombay High Court did not permitted to grant probate in that petition, and ultimately the matter came before Supreme Court, and Supreme Court passed such direction that it may be treated as LA, though it has been filed as probate, but it may be treated as LA, and permitted that substitution before the Supreme Court. The next question is conversion of probate proceeding into LA proceeding. Sometimes it is seen that during the pendency of probate proceeding, the petitioner dies, and it is known to the parties that there cannot be any substitution, then an attempt is being made to get the proceeding converted into a later administrative proceeding. It is also not permissible. In this context, it is sufficient to say that probate petition after death of petitioner cannot be converted into LA suo motu by the court or on the prayer of heirs of the deceased petitioner. Leveling of section in petition is not material, and hence such petition cannot be rejected on that ground. For example, probate petition under section 276 has been filed not by the executor, rather by the legatee or beneficiary, then no probate can be granted to such person. But on this ground, petition cannot be rejected. The safest course is to permit the petitioner to amend the provision of law from section 276 to 78 if there is no will. If this fact is unnoticed and detected at the fact end of the proceeding, then the court shall treat such petition to be under section 278 and grant LA instead of probate. Even when prayer is for grant of probate under section 276 and petitioner is not an executor, LA may be granted. The next question is about contentious proceeding and its procedure. If the probate/LA petition becomes contentious, then the issue of contention is required to be decided by the probate court, for which the procedure of CPC for the trial of a suit as nearly as may be possible shall follow, as per section 295 of the Indian Succession Act 1925. After contention, probate/LA case cannot be and should not be registered as title suit because there is no such provision in the Act as well as civil court rules. However, in contentious cases, the ADJ or district delegate should send a record of the petition of probate/LA to district judge for entering in suit register, and it may be registered there as a test suit. In such condition, it will only take a form of regular suit, and the petitioner shall be plaintiff and the objector shall be defendant. Such contentious proceedings are not suit due to the fact that suit is being instituted by presenting a plaint and in no other case. After contention in any proceeding, it has got trappings of suit only because of the fact that it has to be registered in the suit register as per the civil court rules, and procedure for trial of the suit is applicable, and therefore it has got trappings of suit, but it does not become a suit. Contentious proceedings have trapping of suits only, but not a suit in any view of the matter except the trial of the issue in accordance with the regular suit. Then most important question is, in every probate/LA petition, either it is contentious or not contentious, the points in issue which is required to be decided by the court is very material. Then question emerges is, what is required to be decided in a probate and LA case? First is soundness mind of the testator, or in other words, sound disposing mental capacity of the testator. Second is valid execution of the will by the testator. Third is valid attestation by the attesting witnesses. And fourth is the execution and attestation of bill must be from all suspicious circumstances. All these four important factors are required to be decided by the probate court either in one issue or in two issue or in three issue or in four issue as per its convenience. But the points should be framed like that, which must cover all these 4 points for giving finding on all these points separately or collectively, whatever may be. It would be more appropriate and justifiable to frame 4 separate issues and to decide accordingly. In order to consider 4 above points, Section 59, Section 63 of the Indian Succession Act must be taken into consideration, as well as Section 68 of the Evidence Act, which are required for proof of any document, and the document of will also is covered by Section 68 of the Indian Evidence Act. Therefore, what would be the cumulative effect of Section 59 and 63 of the Indian Succession Act, as well as Section 68 of the Evidence Act, is material. Then relevant sections for reference in such proceeding are 276, under which the petition is being filed either for probate or for LA on the basis of a will. Section 278, which is in respect of LA but without any will. Then Section 279, 280, 281, 283, 284, 286, 289, 290, 294, 295. All these sections are relevant and materials where other aspects have been dealt with by the legislature in the Act itself. So these are some points which are to be kept into mind by the designated officer, either he is a district judge or he is an additional district judge acting as district judge under the Act, or if a delegate is being appointed, any inferior officer, while acting as a delegate for the district judge and duly appointed or notified by the High Court in terms of Section 265, then that such delegate shall consider only non-contentious cases. So this is all about short commentary on these two aspects, and now this commentary is concluded at this juncture. In the next lecture, all the judicial officers and members of the bar shall get an opportunity of knowing about all the important, relevant and selected judgment of the Honorable High Courts as well as Apex Court on each and every point. So let us wait for the next lecture on those case laws. That is all.